right to vote per se is not a fundamental right. And with reference to the earlier two judgments in Kuldeep's case also, the court proceeds to hold it is a statutory right to vote. Is it a statutory right? Is it a constitutional right? What is your? Is it a statutory right? Is it a fundamental right? Is it a constitutional right? The right to vote as such. The matter is no longer res integra. The matter has been settled by this court. There was a division of opinion. When it is referred to as three-judges bench, it was answered in 2013, 10 SEC page 1, popularly known as a Nota case. So kindly turn to that because we have to go by that process. 2013, volume 10 SEC, it is not part of the common compilation.
I just give it.
Yes.
2013, volume 10 SEC page 1. For that, you could possibly go through that. The earlier judgment in the democratic reforms case, that is 2002-5.
Which paragraph?
Paragraph 28.
20.
Because the question arose whether the petition under 32 is maintainable. Answering that, and with reference to the earlier two judgments in Kuldeep's case also, the court proceeds to hold it is a statutory right. But then there is a facet of it which, because the freedom of expression, to know about the antecedents of the candidate without information being made available in a democracy, rights cannot be exercised.
Absolutely. There can't be any disagreement.
So there the court said, if you
may I read para 21? A three-judge bench of this court comprising so-and-so, separate but concurring opinions made observation as to the right to vote being a constitutional right, if not a fundamental right which reads under. In Jyoti, this court again pointed out in no uncertain terms, the right to elect, a fundamental though it is a democracy, is anomalously enough neither a fundamental right nor a common law right. It is pure and simple a statutory right. With great reverence to the eminent judges, I would like to clarify the right to vote, if not a fundamental right, is certainly a constitutional right. I stop here for a minute.
please read on. We'll not yet over because it's a beginning of a.
This right, the right originates from the Constitution and in accordance with the constitutional mandate contained in Article 326. The right has been shaped by the statute, namely the Representation of People Act. That, my understanding, is the correct legal position as regards the nature of the right to vote in election to the House of the People and the Legislative Assembly. It's not very accurate to describe it as a statutory right, pure and simple. Even with this clarification, the argument is learned Solicitor General. The right to vote not being a fundamental right, information which at best facilitates meaningful exercise of that right cannot be read as an integral part of any fundamental right, remains to be squarely met. Similarly, so the right to vote, the election to House of People, Legislative Assembly is a constitutional right, but not really a statutory right. Freedom of voting is distinct from right to vote, the facet of the fundamental right enshrined in Article 19(1)(a). The casting a vote in favor of one or the other candidate marks the accomplishment of freedom of expression of the voter. And that's the issue in this case. Except the above two paragraphs, the aspect has nowhere been discussed or elaborated wherein all the three judges in the separate but concurring judgments have taken the pain to specifically distinguish between the right to vote and freedom of voting as a species of freedom of expression. In succinct, the ratio of the judgment whether though the right to vote is a statutory right, but the decision taken by a voter after verifying the credentials of the candidate either to vote or not is his right of expression in Article 19(1) of the Constitution. As a result, the judgments in Association for Democratic Reforms and PUCL have not disturbed the position that a right to vote is a statutory right. Both the judgments have only added the right to know the background of a candidate is a fundamental right for a voter, so that he can take a rational decision of expressing himself while exercising the statutory right to vote. In PUCL, how the voter's fundamental right to know the antecedents of a candidate independent of statutory rights. Under the election law, the voter is the first citizen of the country and apart from statutory rights, is having fundamental right conferred by the Constitution. And Venkatramani said, so the initial right cannot be placed on the pedestal of a fundamental right, but the stage when the voter goes to the polling booth and casts his vote, his freedom of expression arises. The casting a vote in favor of one or the other candidate tantamount to expression of opinion and preference at that final stage in the exercise of the voting right marks the accomplishment of freedom of expression of the voter. That's where Article 19(1)A is attractive. Freedom of voting and the distinction of the right to vote is a species of freedom of expression and therefore carries with it the auxiliary and complementary rights such as the right to secure information about the candidates which are conducive to the freedom. After, in para 25, after careful perusal of the
come to the middle of the next page because we can save time. Page 19, towards the middle of that para,
this page,
the court goes on to say, thus there is no contradiction as to the fact that right to vote is neither a fundamental right.
Yeah, thus there is no contradiction as to the fact.
But
as to the fact that the right to vote is neither a fundamental right nor a constitutional right, but a pure and simple statutory right. The same has been settled in a catena of cases and clearly not an issue dispute. With the above observation, we hold that there is no doubt or confusion assessing the constitution by judgment in Kuldeep Nair and do not stand impliedly overruled.
Now you come to para 28.
The decision taken by a voter after verifying the credentials of the candidate, either to vote or not, is a form of expression in Article 19(1)A of the Constitution. The fundamental right in Article 19(1)A, read with the statutory right in Section 79, is violated unreasonably if right not to vote effectively is denied and secrecy is breached. This is how Article 14 and 19(1)A are required to be read for deciding the issue raised in the petition. The casting of the vote is a facet of the right of expression of an individual, and the said right is provided in Article 19(1)A. Therefore, any violation of the said right gives the aggrieved person the right to oppose this court in Article 32. In view of the aforesaid decisions as to the observation of the Constitution being, a prima facie case exists for the exercise jurisdiction of this court under Article 32.
So we have a quaint sort of mix of principles. The right to vote per se is a statutory right. But certain aspects, facets of that right, they are part of the fundamental right under Article 19(1). For example, I have a right to vote, but I have a right to receive information, be fully informed about how I go about exercising that right. I have a right to say that I will not vote for anybody and say press a nota button.
Correct.
So the fundamental rights are actually read into the statutory right. So why we have made this effort is to bring home the fact that we may have to proceed on the footing that the right to vote simpliciter is a statutory right. So the three judges, right, unless they are able to show something else. But then your woes are not an end because of that. Because the fundamental right is again read into, as we have pointed out to you, paragraph 28, the facet of how you express yourself. It's part of the right inherent in every citizen. There is a part of the fundamental right in the right to vote. Absolutely. In other words,
I quite see that.
So your objection to not, making use of Vishaga in the region of Article 324 may not be fully right, except to the extent that the right to vote per se is not a fundamental right. Second thing is the reservoir of power, which is actually, with the Election Commission of India is so wide. That's what the court keeps on saying. If you see the association judgment, court has used Vishaga in 324. But that was for the purpose of the statutory power. That association case, 2002, 5 SCC 294, Vishaga is used in para 34 to 37. Whether it could be done. But that is again, you're right there, that is again in a statutory context, not in a constitution provision.
I right. Your Lordship.
But the fact remains that there is a fundamental right.
I'll try to find where one can have a little more dialogue.
Yes.
I'm thankful.
Yes. If I may just for a minute, because your lordships are on this issue. One judgment 2016, 2 SEC 445, which is of Justice Chalameshwar and Justice Sapre. Rajbala versus State of Haryana.
Panchayat election.
Yes, the Panchayat elections matter. From para 16 to 38, very detailed discussion on this, on the right to vote and the right to be elected, both. And there are many new judgments that they look at, but I must say that this judgment is not looked at. PUCL is not looked at. 3 judges, which they would have had to consider. But they consider the earlier PUCL 5 judges, which said it's a constitutional right. 2016. 2 SCC, 445.
educational qualification for the.
Yes, but those paragraphs actually extract each of the paras of all the previous judgments and come to the conclusion of why it is a constitutional.
But without referring to
This is omitted. They've considered earlier 5 judges, but not these 3 judges.
but that is a 2 judges bench.
Yes. But Rajpal has been followed in Puttaswamy also. But again, one of the judges, not all.
That's right, but we have the freedom to take.
Of course, but I'm saying the
We are saying
interpretation.
that we are not bound
No,
by the
you're
2 or
not.
the 3.
Your lordships are not. Your
We
lordship.
are not.
But I'm saying the interpretation, the principles that they have enunciated and the sequence have gone through, I think that's very helpful.
Yes.
And these 2 judgment is laid on a constitutional bench list.
Yes, it's followed reliant PUCL Constitution Bench. That other Krishnamurthy, they said that no, Krishnamurthy didn't consider PUCL. PUCL clearly said that it's constitutional. Paras 18 to 32.
Yeah.
Thanks, my lord. Our case is not merely based on the fact that right to vote, and which is a fundamental right, etc. Our case is based on a larger principle of democracy being part of the basic structure of the Constitution, and free and fair elections being part of the basic structure of our Constitution. And therefore, it is necessary that the Election Commission, which is in charge of elections and democracy, must be an independent body. That's
Because, the juridical premise for Visakha is there were a lot of international covenants entered into, and women had fundamental rights, and Parliament was not responding promptly, and matters were being dragging on. So they said, read with Article 142 and the power under 32, which is for fundamental rights. They said there is a fundamental right with the woman.
In fact,
That's how it is reasoned. That's
Absolutely.
what we have to deal
in
with.
fact, if your lordship sees prior to Vishaka, in gramophone, your lordship said there's a void on copyright law, so the Berne Convention's provisions were read in. In Vellore Citizens Forum on environmental law, you said there's a void, so you read in the provisions of the Rio Convention, etc. You did this repeatedly, my lord. In Lakshmikant Pandey, there was void. Vishaka followed that sequence.
That, the matter of international covenants.
Yes.
That's a slightly different.
That's a slightly different thing.
Slightly
But
different
the
area.
question is when there is a vacuum, your
You
lordship
can read it in the case of the
Correct.
international covenant.
and the rights which are being agitated, which is why your lordship will look at this point. Because in
We are just
Vishaka,
being clear, because
Yes.
it is a right to vote per se.
correct,
We cannot ignore the fact that it is a statutory right.
correct,
For example, supposing you say there is a fundamental right.
correct.
At what age do you exercise your right? If I am a citizen, I am born.
Yes,
Okay, I am 1 year old.
yes.
Can a 1 year old walk into the booth and say, please allow me to cut my vote?
But
I
that's
must
regulated
first
by
of all-
326 in its
Exactly.
own words when it
That's
says
it.
adult suffrage.
Therefore, I should be 18 years.
Yes,
Correct.
yes.
Then I should various disqualifications, qualification. They're all prescribed in the statute. So they
Correct.
give the right.
Correct.
The
That's
Constitution does not
No,
clothe
it
any
doesn't.
person with the right to vote.
which is why, my lords, those who are in prison don't have the right to vote.
Exactly.
Which is-
Exactly. So therefore it is a statutory right. Aspects of it, that statutory right are
Absolutely.
part of covered by 1918.
Correct. And those rights, when they're being agitated by us, when we find a vacuum, your lordships will do what is necessary. If an international convention,
That is a question.
that's
A question how you go about it. See,
Absolutely.
What the Attorney General is addressing us is a concern
yes,
that bearing in mind the broad separation of powers. We don't
Correct.
have the separation of powers as we have in the United States.
yes,
But we have over a period of time evolved the principle of separation of powers
yes,
in a partial way.
yes.
Because if there is separation of powers, we wouldn't be having 356.
Absolutely.
That is one example where
Yes.
in the earlier judgment of 62 Supreme Court, they say, no, it's not a case of pure separation of powers, partial government.
Yes.
We should not, overreach our boundaries.
No,
When we
absolutely.
say that that's the only concern, we should carefully address that.
Okay.
Otherwise, he has pointed out number of statutes, number of provisions in the Constitution where they say subject to law may be made.
We'll show you how those are distinguished.
They are distinguished.
And there
That's a
are
different thing.
categories into which they fall.
No, what you're saying is the restraint should be there. When we
Yes.
say that we should not jump at the idea and say, okay, here we are.
Even
Like
I,
Visakha,
even I,
Visakha
In
is
fact, since your lordships are looking at it right now, just see. There are only 4 provisions in the entire list that the AG gave you, which says specifically with reference to an appointment subject to the provision of law. Which are those four?
They can be the-
324, I'm just telling you, Lordship, 324, 338, 338A and 338B, which were recently introduced. Because the Commission for Backward Classes, SC, STs, etc.
We say that point.
Your Lordship, we see
That we can.
So that, those stand separately.
What you're really saying that, you know, when we are, this is a 5-judge bench.
Correct, correct.
And not easily, you know.
No, no,
We have to
absolutely,
have a 7-judge bench if
Absolutely.
we go wrong.
absolutely.
We have a
can settle
greater
these.
duty to be very right,
Yes.
to be correct.
Correct.
It's not that, you know, we write something
Correct.
and then it has to be reconsidered after 2 months. You have to be careful. That's all
No,
that
but
is.
equally
Whatever we do,
important-
whichever way decide.
Well, it's equally important is that we have an opportunity to settle peripheral issues which have agitated this court in a series of judgments.
Absolutely.
So if
No,
the
no,
right to
no.
vote being a constitutional right, Your Lordship, we settled it.